March 9th, 2026. Cruising on through, aren't we? Sure is flying by. Oh, let me silence that so we don't listen to that during the show. Of course, that was my notification. I'm live on YouTube. So consider yourself lucky on YouTube. I'm still broadcasting on YouTube. I haven't cut that off yet, but I will. Screw YouTube. YouTube sucks. Anyways, hope everybody's doing great out there. We've been getting some pretty decent weather here. Still getting chilly overnight, but fairly nice during the day. So it's that time of year, right? Getting to springtime, and we just sprung forward an hour or so. Man, 1 hour has messed me up. Can't believe it. But want to say hi to everybody out here on Telegram. Tiger, good to see you. Michael Casper, good to see you. JPC5, Jills, Dreaming Deer, DI, Kathy Watson, Wendy, and Diesel D's. Good to see you, brother and sister. Let's see who else is over here. That's Kristen, Palindrome, Paint Gun Spooty, in the comments over here. So good to see y'all. Karen out on Rumble, good to see you. Yep, strengthening and unleashing America's law enforcement. Yep, that was that executive order that I went over again yesterday. The one I went over on March 2nd and explained to people that public corruption complaints, right? And JJ, you know, you're making the comment in there about doing that stuff. That's what I covered in that Monday Night Law on the 2nd. And as for the evidence, well, like I showed there, you can upload, I guess I didn't actually show it, but it's in there when you go into the complaint. You can upload up to 5 documents, PDF files. So, I think it was up to 10 megabytes. So, you're easily able to upload your evidence. But the thing is when you file the public corruption complaint, they may contact you for evidence. But you could submit some of your evidence through there as well. That is the avenue that Trump has made available for us under basically it's an extension of DOGE, waste, fraud, and abuse, corruption. Okay? So, YouTube, Heath Wilson, and Wendy over on Facebook. Thank you, Wendy, for running around checking everything. Jax, good to see you. So, yeah, it's, that's what we can do. It's always looking for that to answer that multi-million-dollar question, right? Is what can we do? And, I've been putting that out. It's in my educational series. That initial was an executive order by Trump, the waste, fraud, and abuse and corruption, public corruption complaints. Okay? The A091 form going to the federal deputy attorney general's office. Well, now they've got it set up through our state attorney general. And like I've discovered, and I showed on Monday Night Law on the 2nd, March 2nd there, is that they amended it to go all the way down to city level. So this is on our local level, folks. And I want to remind people, I looked into my city, Garden City Police here, okay? There's no elected official there. Some places have elected city police chief. Some don't. But nonetheless, they're actually because this is part of our structural form of government, the militia. Okay, you have the governor, then you have the sheriff, county level, and then you have the city mayor. Those are your commander-in-chiefs in your districts, your areas, right? So you have governor, sheriff, and then the city mayor. Now, at a county level, for like the judges and stuff like that, that's city council. Or pardon me, county commissioners. At a city level, that's city council. So city council is like the legislative branch. The city mayor is the executive. Okay? Now, we're supposed to have justice of the peace courts at a city level. Where are they? Well, they just got rid of them. Now they call, like here in Idaho, they call it the magistrate division of the district court. Some states call them superior courts or circuit court. That's back under Roman civil law. So, structurally, our Republican form of government has been altered. So, this will be part of what's going on with Toll and Roll, and, I'm going to have to put some stuff in there for that. Not only that, I'm going to be doing my own constitutional challenges here in Idaho. So, get prepared, Idaho, because you might have a little extended legislative session this year. Just saying. Because not only am I going, it's going to be twofold. Right? In the judicial and the legislature at the same time. Double petition. Petition to the judicial and petition to the legislature. Okay? So, right now I'm still just buried playing catch up on my mom's paperwork. Plus, I got to get my paperwork in by Thursday for my case, for notice of appeal, and I'm going to do a formal written judgment of acquittal, motion for judgment of acquittal. So we'll see that. But we'll see what happens there. He can deny. It's all going to come on him, though. But I've got him so tied up. This is going to be one hell of a nightmare of a mess for an appeal. And all of the errors that I will be pointing out. And that the appellate court is just going to have to address. All these errors. And of course, my public corruption complaints. So, boy, it's my turn, right? Now it's my turn. And then I get to file my lawsuit, right? So, not only am I going in for the constitutional challenges and independent action, I'm going to go after them for violating my rights. All of them. Big time. So, like I've said before, this is prime time, prime picking, folks. We need to be doing this stuff. And see and I keep trying to tell people, we got to do this so that it affects everybody. Right? Not just myself. So, this is what I was talking about before is, I want to train warriors to do this. We need warriors to come out, step up, those that have standing to claim their right to a cause of action, and go after them and take this down for everybody. Okay? So that's over through my Patreon, Wednesday night workshop, kirkslawcorner.com. Links are in the description there. Donations, if you'd like to make a donation through there, the Buy Me Coffee. That one is set up now. It's usable for making donations, which also accepts cryptocurrency. So if you want to donate in crypto, you can donate in crypto. Although I don't have any cryptocurrency, but it'll transform it for us. So, James on YouTube, no, it's a petition, not a remonstrance. Something that I learned after Chris was murdered is there is a clear distinction between a petition and a remonstrance. A remonstrance is a formal written protest that you're protesting against legislation being made, in the middle of it being made. Okay? A petition is a political lawsuit, just like a petition to the judicial branch is a judicial lawsuit. See, a lot of people don't understand. The legislature has a court. The courts that are actually supposed to be the courts of justice are in the legislature. Courts of common law are in the judicial. Right. So, petition to the legislature for the redress of grievances is a political lawsuit. So, that is the clear distinction between a petition and a remonstrance. And the petition has a prayer for relief. We get to make our demands of what we want them to do, the relief that we're seeking. The petition process is the remedy. Okay? Remedy is process. Relief is what you're demanding. You're welcome, James, and good to see you, brother. I think it's the same James that I'm thinking of. Long time no talk, and man, there's quite a few of men out there that I've just been so busy with life that I would love to reach back out to, and get people together. Man, there's so much that we need to learn right now, and implement it nationwide, folks. And there's some law guru people out there that I've been in contact with. You reach out to me, guys. You know who you are. We've had conversations. One's out of California. I mean, all over. Gus Brenton, Derek Gonzalez, James. If it's the one, there's another James Patriot. There's a couple different James. So I know at least two different Jameses. Please send me an email. Send me a message. I'll get back with you, but I need your contact info again. I might have numbers saved in my phone. I don't know. If you have my phone number, send me a text message. Say, hey, this so-and-so. Remember me? Give me a brief reminder. But typically I don't forget people that I've talked to on a serious level like that stuff. So, if we've had like a couple of hour conversation, yeah, I want to talk to you. I want to continue our rapport and invite people on here to the show, and let's have a big old round table discussion, folks. Let's bring the most intelligent men, like Montesquieu talks about in his Spirit of Laws. Let's bring all the intelligent men of the nation together here, and let's put our minds together, and let's bring you on board with Toll and Roll. Let's bust this stuff out. Let's bring forth real law, proper diction, and take this corruption down and restore the republic that it's supposed to be, and restore the power back to the people. Grand juries, where we can do our own, right? We can assemble our own grand juries based on our own information. That's the original prosecution by information. Not the Roman civil law prosecution by information, but based on our own information, we can have that right to peaceably assemble. That's actually what that's talking about. Right? Article 1, Section 2, Vital Constitution, the right of the people to peaceably assemble, right? To consult for our common good. Actually, no, that's Article 1, Section 10. And instruct our representatives. That's the grand jury. And that is what's called a presentment. When it goes through the judicial branch, when somebody lays a complaint before a magistrate, and the magistrate says, yeah, okay, when the injured party, the complainant, takes the stand, sworn in under oath, testifies, reduced to writing, signed, sworn, and subscribed, then it gets sent over to to form a grand jury to do an investigation on that particular case. Right? Grand jury. We're the ones that are supposed to be doing investigations. Not the government. We are. So, until we reestablish the people, see, this is the problem with American state nationals. They're not the people. They think, for those of you out there that think, oh, you got to correct your status and become an American state national, and then citing United States Code, Roman civil law, you're actually putting yourself back in under the Reconstruction Acts and then Roman civil law, the code, okay? Not taking yourself out of it, because that's not a legitimate status. We have citizens, we have the people, and we have inhabitants. I've put this challenge out there before, many times, and I'll put it out there again. I'll challenge any man right now to prove that national is a political status prior to the Reconstruction Acts of 1871, considering national in that Title 8 U.S. Code, blah, 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 Immigrations and Nationalities Act, did not come into being until what? 1887. So, how do you reconcile that that's a political status here in America from 1776 even into 1789, 1791 with the Bill of Rights? It didn't exist. But see, there again, people do not do the research. They just follow blindly, right? Just following blindly. Nobody's paying attention. Nobody does their own research. So, again, I'll put that challenge out there again. I've not had one man or woman say that they accept that challenge. Come on my show live and let's debate American state national is legitimate, lawful, that it's not fraud. It is a fraud, and I'll call it out, and I've called it out as a fraud. For many years now, once I discovered, because I did my own research, yeah. So here's where I'm at. How do I change my status from man, creation of God, to an American state national? No thanks. I'll stick to being man, a creation of God, and one of the people of the territory of Idaho, the landmass. Not the state of Idaho, the corporation. So, James 3.14. Excuse me. James, how come you can't chat over there on Rumble? What's wrong with Rumble, guys? Oh, Munson58, good to see you. No, Wendy, James was saying he was having a hard time making comments on Rumble, so, or I couldn't chat at Rumble. Oh, you have to be you have to have an account with Rumble in order to make comments on Rumble. You can watch without having an account, but you can't make comments. So, yeah. Yeah, that's probably the problem, James. You don't have an account on Rumble. So, oh well, so be it. But yeah, same with YouTube. You got to have an account on YouTube to make comments on YouTube. So, uh, but you know, to each their own. And like I've said before, though, a lot of this is going to switch over to pretty much just Rumble only. So, and I see you out there, Jameskin. Good to see you, brother. Harold Eugene, good to see you out there. Tammy Tansy, hope I pronounced your name right. Yep, I know. A lot more people are waking up these days. It's become exponential over the last, really over the last 4 or 5 years. But hey, good to see you, Doug. Huh, weird. Kim Fry, good to see you. But yeah, we need to come together, folks. And as far as I know, I'm the only one out here teaching how to do this stuff, how to file the public corruption complaints. Now, somebody else has copycatted me, learned from me, and out there charging people for it when I've put it out here for free. Um, you know, teach your own. You know, you want to go learn from them, pay them to do it. That's fine. But if you want to learn from the man who actually figured it out and had a little bit of help with the A091 direction, that'd be me. Come learn from me. Right, Karen? Last week hit the spot for many in other countries as well. Oh, absolutely. Ah, you're funny gal there, Karen. But yeah, you know this. As far as I know, I'm the only one teaching this stuff, teaching real law and the history of law, going through things like Montesquieu and teaching different forms of government, fundamental law. You know, uh, where else have you heard about fundamental law? You know, Roman civil law, feudal law, and common law. What about the different forms of republics? You know, there are three types of republics. You have an aristocracy, a democracy, and a confederacy. There's some people out there that say, oh, well, confederacy is not a form of government. Yes, it most certainly is. And we are, in fact, a confederate republic. It's all over in Federalists' papers. It's right in the Articles of Confederation. The style of this confederacy shall be the United States of America. That is the proper title with a capital T, the, and a capital U in United. Not this crap of lowercase u and all. No. Read the Articles of Confederation. Okay? The style, right? The name and style of this confederacy shall be. That is mandatory language. And then if you read the preamble, what does it say? In order to form a more perfect union, which means we already had a perfect union, and a union is a league of friendship, which is a confederacy. which is a republican form of government. So, there you have it. And it's right in Article 6, Clause 1. As under the Confederacy, all of the debts and da-da-da-da-da, right, engagements entered into. But it's right in the preamble. In order to form a more perfect union. You can't get away from facts of law as it is written. Period. So, and had nobody bring any proof to the contrary, I mean, other than their opinions, and like, oh, well, yeah, no, but they got rid of the Articles of Confederation. No, they did not. In fact, read the Articles of Confederation, and then read the Constitution. Most everything that's in the Articles of Confederation is in the Constitution. No, it was in order to form a more perfect union. But the truth is, the real truth is, read the secret debates and proceedings of the Constitutional Convention there. They weren't supposed to be making a new constitution. They were supposed to be making amendments to the Articles of Confederation. And the only two real things that they were supposed to be dealing with was, one, regulating foreign commerce, how to regulate foreign commerce, and then calling forth the militia to defend the Union. That was the two main things that was missing from the Articles of Confederation. Now, I'm very well aware that their claims were, well, the Articles of Confederation was just too limited in our scope and power. Exactly. And you were only delegated two different things to add to the Articles of Confederation. But when you read that secret debates and proceedings, you find out that they knew they were usurping their powers. That's why Patrick Henry resigned as a delegate and said, I want no part of that. You guys are usurping your powers. They knew they were usurping their powers, and there were several delegates that spoke up and said, I'm not on board with this. We're usurping our powers. And then later down in the debates, they say, oh, yeah, sorry, blah, blah, blah. Yeah, we're going to go ahead and do this, knowing that we're usurping their powers. And then, well, the people can just deal with it later if they don't like it. So, honestly, lawfully, the Constitution of 1789 is a fraud. It is in direct violation of the Articles of Confederation. The secret debates and proceedings prove that they usurp their powers, and means that Constitution is void for any effect. Not only that, read Article 7 again. Oh, 9 states shall be sufficient to... Nope. You have to have the consent of all of the states. And that is an article in the Articles of Confederation, Article 13. Uh-oh. So, on 2 counts, the Constitution is void for any effect. I don't care if it was later down the road, the other 3 states said, yeah, no. You didn't have all 13 to begin with. So, yeah, you're right, James. It was the bar. Drunk on power. Absolutely, brother. Yep, you got it right there. Now, my brother Rob Lowe got here. I think he found something was Louisiana was even did the code Roman civil law. I think it was even in 1812. But I have confirmed New York and California did in 1845. I have confirmed Idaho in 1881. So we need to get rid of this Roman law, this Roman civil law, the code, and get it out of our republic. It is and it's in the Declaration of Independence, folks. Subjecting us to a jurisdiction foreign to our Constitution, unacknowledged by our law, and given his assent to their pretended acts of legislation. That's the code. And that's how civil law works, is through bills of attainder and bills of pains and penalties. Napoleonic or Justinian, the Justinian Code. But there was several others that wrote code, but that's a foreign jurisdiction. Both Montesquieu and Blackstone in his commentaries on the laws of England lays it out there, and that the civil law is opposed to the common law. It's opposed to the laws of nature. Why do you think we don't have these rights in courts anymore? Because they're all under code. It's all civil law. Civil law, we have civil rights, which are privileges that are granted. Where's our natural rights? From the laws of nature, from God. Oh, we don't have those. You only have civil, because it's civil law. Yeah, that's why. That's the trickery. No, natural rights and common law rights, the rights that are all common to all, and the law of the land is the common law of the land, which due process of law is synonymous with law of land. So, when we say these rights, life, liberty, and property, cannot be deprived without due process of law, that means from the law of the land. Right. That we, the people, dictate. So, that's up to us, right? We hold all of the political power. So I'm going to totally destroy their whole argument when I go in, oh, well, we have broad, sweeping policing powers. No, you do not. We, the people, have all of the political power, and you only have certain powers that are delegated by and through the Constitution. Because that's the instrument of government, and that is how the people delegate certain powers. You only have those powers that are delegated in the Constitution. See the 10th Amendment. Reserved to the states respectively or to the people. Then read every Declaration of Rights for every single frickin' state, and it will say, all political powers inherent in the people. They have the right to alter, reform, or abolish anything at any time they deem it necessary. So therefore, all of the power is actually inherent in the people. So how does the legislature, executive, and judicial branch get their powers? By the consent of the people. Otherwise, you don't have it. I finally put that pieces of the puzzle together to rebut their garbage about we have these broad and sweeping policing powers. No, you do not. Well, yeah, but that's only for the federal Constitution. No, read the 10th Amendment again, or to the people. And then read every single state Declaration of Rights laying down the law. That's that due process of law from the Declaration of Rights. That's due process of law, the law of the land. So, like what we say 4th, 5th, and 6th Amendment from the Bill of Rights, That's due process. Plain and simple. That's the process that is due. From the law of the land. Not from a statute. Uh-oh. And then remember this one. Statutes in derogation of the common law must be in strict, or shall be in strict compliance with the common law. Why do you think they have to keep going back to the common law to find what the common law says at the time, like in Idaho in the State versus Clark case? Well, what does the common law say at the time of the adoption of Article 1, Section 17? Oh, yeah. Where do they go? Straight to Blackstone's Commentaries on the Laws of England. That's the first primary thing they go to. That's the go-to. So, plain and simple. Tim and Drizzle, or Time and Drizzle, you're citing United States Code. That's Roman civil law. Try go and read Law of Nations. See the problem here? People's choice of law is in error. Blue Sky out here on YouTube. Why do policy code enforcers perform 4 functions? I don't know. The Bill of Rights says that we're supposed to have a well-regulated militia being necessary for the security of a free state. And I'm sorry, but the policy officer, it's not pronounced police officer, it's policy officer, was actually created by the king in the early 1700s to man the ports because his military, whatever they want to call him over there, the guard, he didn't have sufficient men to defend the realm. So he created the policy officer to man the ports to regulate commerce. That's where the policy officer was instituted, and why it's in the Declaration of Independence as erecting a multitude of new offices, sending hither swarms of officers to harass our people and eat out our substance. What do you think they're talking about there in the Declaration of Independence? He's talking about them policy officers. Why do you think they said no standing armies, which is no armed bodies of men? That a militia being necessary for the security of a free state. And in the Arts Confederation, the militia is composed of the body of the people themselves. Northwest Ordinance. 1787. So soon there shall be 5,000 men, who give notice to the governor. That's the militia. That's also, the militia is also the pool of the people. And then we have qualified electors from the pool of the people. So, again, I have to apologize to the women out there, but this is the way it's supposed to be. The men are supposed to be in politics and in government. The men are supposed to be fighting, right? Getting back to the what God has intended for our traditional family unit here, the husband being the head of the household. And I'll say this again, man and woman, right, get married, husband and wife. It's a union of souls to become one. And it's such a beautiful thing. It really is. Read many of the former, founders and all this stuff. They all wrote and communicated with their wives. They sought counsel from their wives. Right? I'm not saying that women aren't worth anything, that they're no good, that they should just be sit at home, you know, housewife and all that stuff. No, 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 no. To the contrary. Women make us the whole, right? One half. It's the other half. So, again, women are very beneficial. And typically speaking, you know, men we're more of the arrogant, strong-willed type of men, and women are the softer, emotional side. So imagine the marriage, the union of the strict sternness, stubbornness of a man, and the soft, emotional side of a woman, and you put the two and two together. What do you get? Something really beautiful. Gee, I think God was pretty smart when he did that. So, that's what I believe about how things are supposed to be as God intended. So, for those out there that try to twist my words about, well, only men should be in there, that I'm sexist. No. It's not what I'm saying. Right, Diesel Deed. Feminism knows better than God. No. There's quite a few women out here that agree with me on exactly what I just said. And I've seen plenty of other videos of women out there saying the same thing. So, we need to get back to these fundamental principles. We need to have that frequent reoccurrence to fundamental principles. And the traditional family unit is one of them. And let's kick government to the curb. Get back to a limited form of government. No, Peep out here, or Pep, P-E-P, out here on Rumble. No, civil rights are from Roman civil law. We either have natural rights or political rights. That's political power, political rights. So like the governor has political rights. Does that make sense? That civil comes from Roman civil law. It's trickery. I know. It's bar word salad. It's trickery. Believe it or not. Thank you, Trisha, over here on Telegram. Totally agree with me on that assessment on husband and wife team. Right? Again, it's a team. It's a union of souls together. Right? What is marriage? It is a sacred vow between a man and a woman unto God till death do them part. It is, in fact, a union of souls. You become one. Art out here on YouTube. Fundamentals, not fundamentals. Oh, Lordy. Good stuff. Jacqueline, New Jersey is giving licenses to all illegals. Well, they're going to get themselves in trouble. Right, Karen? It's an everyday learning thing, right? And one of the old sayings is, I learned something new today, right? We learn something new every day. Well, guess what? Guess what I learned today is what I learned yesterday was wrong. So, don't always count on what you think that you've learned today is to be correct. Because tomorrow you might find out, oh crap, that was wrong. And I've actually been there. Okay? I actually did some research and thought, yeah, that's good. Just like American State National, right? There's a perfect example. For those of you out there that did correct your status or thinking about correcting your status, American State National, And you're sitting here listening to this video, or you're watching it live right now, or you watch it later. And I'm telling you, American State National is a fraud. It's under Roman civil law, the code. Show me from the law of nations where national is a political status. You will not find it there. I know, because I've read it. It doesn't exist. I also have done the etymology on the noun as national. Did not come into being until 1887. So you will lose that debate. You will not be able to produce any evidence to support your claim that national is a proper political status here in America or in any other nation. Yeah. Read the law of nations. That's the law of nations. So, Jane Fair out here on Telegram. Good question. Honestly, I had a hard time with this. I used to fight with the judge. So the question is what do we do when the judge ignores even the plainly written law? I just experienced this myself in my trial under jury instructions. Okay? So you object. You object to their misinterpretation of the law. And then when he denies your objection, you object to his denial of the objection. So it's a double objection. And that is an error in the record. Every time we make an objection, that's saying, hey, there's an error here. You need to correct the error. And if your objection is overruled, then you object to the overruling. Okay? So, then that becomes an appealable issue. Now, on appeal, the only thing under review is errors in the record. You cannot relitigate your case. On appeal, they're looking for errors made by the lower court. And to either send it down for trial de novo or just go ahead and grant you relief. So, but most of the time, it's to vacate the judgment and trial de novo. Do it all over again. The problem is all of the errors that they have previously made, they can't try it again. So, like in the State versus Clark case, they just vacated the case and said they're done. There is no trial de novo. Plain and simple, done. So, to answer your question, Jane, which is, again, I know that's a very, very highly sought after answer to that question. And what I've learned is, I'm there to create my record. Don't let them get to you. Don't let them get to us. Keep your cool. Know what you're doing. Know that you're there to create your record. I don't care how he rules. I will hold him responsible later. They want to play that psychological warfare game on us. Psychological operations. Okay? So, this is where knowledge is power. When you know that the crap that they're citing is unlawful, you call it out. You give them notice. And when they deny that, you object to that. Okay? And you say, okay, you want to play this game with me? If you're going to do whatever the hell you want to do, catch you if I can? Okay. Keep your cool. Do your objections and move on. Don't fight with the judge. Right? Make your argument on your objection. Let the judge rule and move on. Create your record. Do not let them get to us. Don't get all riled up thinking that you're going to fight with the judge to get your way. Nope. Right. Okay. Perfect example, Jane, right here. Oh, well, pointed out that the burden of proof, because they said she didn't prove her innocence. I pointed out the burden of proof, and she said that they didn't care. Great, that's on the record. But did you ask the question of law? Is a man innocent until proven guilty? It's a question of law. So you have to pose it as a question. Hoorah! Semper Fi, brother. Out there on YouTube. TYJ fam. So, yeah. Ralph K., what do you do if you forget to bring up some issues that you found out before it goes to the appeal court? You have to, right in the very beginning of the cases, all of your affirmative defenses, okay? All of that stuff has to be done in your initial pleadings. And let me tell you, they prey on our ignorance. But make no mistake, I'm getting way better at this. And I've taught this stuff in the educational series. Okay, for those are on YouTube. Okay? Jane, okay, what happens when the judge refuses to let you speak? It depends. What are you there in court for? Right? You can't just arbitrarily speak. You've got to put some paperwork in to be heard. Right? You've got to make a motion. And this goes to answer Ralph's question twofold here. You have to put it on paper. Because that's the first primary, the first fundamental principle of due process of law is notice and opportunity to respond. Okay? So you have to give them notice. And then you can demand a hearing on that motion. Right? Then it's your turn to speak. Okay, when you file a motion, you have to call the clerk of the court and say, hey, I need a court date for a hearing on the motion. And that sets the timeline in accordance with the rules of procedure, or sometimes they will have local rules. So you want to make sure that you check your rules, but generally speaking, it's 21 days to respond, and then if they don't respond within 21 days, then you can move for default judgment. If they do respond, then you have 10 days to respond to their objection and then move for summary judgment. That's the two different ways to handle that. Either a default judgment if they fail to respond, or a summary judgment if they do respond and you know that you're in the right. So then you move for summary judgment, and then you have a hearing on that. So, that's the key there, Jane, is you got to make sure that you set it up. So once the hearing date is set, which the clerk will say, oh, well, you filed the motion on this day. The other side has a certain amount of time to respond, so they will set the court hearing out on a certain date. And then you have to do the notice of hearing. Typically it's 10 days or even as low as 5 days before the hearing date. But when we're dealing with like the criminal court and stuff like that, they immediately get notice that you set it up for a hearing. But on the civil side, you have to do the notice of hearing. So, but in all cases, we have to call the clerk of the court, and it's the clerk for your judge, right? So you're going to want to get a hold of the judge's clerk, not the actual clerk of the district court, the elected official. No, the clerk for the judge in that particular court in your case. Okay, yeah, Jane, was just explaining that. So I know that video lags a little bit, but well, you're on Telegram, so it really doesn't lag that much at all. So you have to call, pick up the phone, and literally call the judge's clerk to schedule a hearing on your motion. Whether it's criminal or civil, it doesn't matter. This is due process of law. That's how we do that. Okay? Hi, Virginia. Virginia Rowe Official out on YouTube. Good to see you. So, Jeremiah Thompson, no. Facebook out here, no. It is not all trust. It's Roman civil law, the code. Learn, people. Learn the truth. Oh, well, it's administrative, or it's this, that, and the other. No, it's Roman civil law as a fundamental law. There are 3 fundamental laws: Roman civil law, feudal law, and common law. Pick one. The problem is this is all Roman civil law, the code. Penal code, United States Code, Idaho Code, Code of Federal Regulations, Uniform Commercial Code. Code is Roman civil law, folks. It is a jurisdiction foreign to our Constitution and unacknowledged by our law. It is shit made up by the bar, maintained by the bar, and enforced and adjudicated through the bar. That's the truth. That's what we need to be saying, and I have the factual evidence behind it. Period. End of discussion. It isn't anything else. Let's start calling it what it really is. Okay? Because that's the truth. Factually, lawfully speaking. So, the sooner we all get on board with learning the truth and how to properly articulate this, the better off we're going to be. Because the truth is what sets us free. Make sense? I mean, you know, I've gotten to this point where I know I can't go back. Right? I can't go back to not knowing that this is Roman civil law. How do we win in Roman law? You object to it. You don't want to be in Roman law. It's a foreign jurisdiction. It doesn't belong here. It's foreign to our Constitution, unacknowledged by our common law. Plain and simple. Get that Roman civil law crap out of here. It don't belong here. It's a foreign jurisdiction. I'll tell you what, the stand-in judge for my trial there, when I was laying that all out, boy, did he get uncomfortable. Now, here's your symbolism again. Does that magistrate up there, judge, whatever they want to call themselves, are they wearing a black robe? Why are they wearing a black robe? That is symbolism from the Roman Catholic Church. This is all Roman law under the ideology of Catholicism and not under the ideology of Christianity with the laws of nature and the common law as our fundamental law. That's the truth. And it's right in our face. There you go, Art. That is insurrection, domestic violence, pursuant to Article 4, Section 4. Not the Violence Against Women and Children Act of 1995. Right, Ruff? Good to see you, brother. He'd be retiring soon, too, I'm sure. Oh, yeah. A lot of these so-called judges are going to be retiring here real soon. Whoa. There'll be a bug in the house. Oh, it's a moth. Big one. So, anyways, that's the key, folks. Knowing our laws. Right, Michael Casper? Retiring to Gitmo. Absolutely. James, I get rid of the A. I am man. Not I am a man. I am man. Creation of God. So, yeah, dude, this is what we need to learn, and I'm trying to expose this like nobody's business, because that's what's really the problem, is this Roman civil law, this code. Okay, and once we figure this out and we start calling it out, so if it's Roman civil law, can you send notice to bishop? No, you object to it. Lack of jurisdiction. Their choice of law is in error. And I don't consent to your choice of law as the Roman civil law. Plain and simple. We have to object to it. We have to give them notice. And like I said, when I started talking about that before the trial and all that stuff, when he was asking me about what's my motion objecting to the presumptions of law here, I'm talking about the code, right? And my buddy's here behind me. Oh, Peterson versus Peter. Yeah, I know. I was getting there. Well, it was just on the tip of my tongue. But Judge Eisman in 2014, Peterson versus Peterson, out of Supreme Court, said that the Idaho Code is not the law, that it is a mere compilation. And so that is the presumption of law. And I said it's in the rules of evidence that this is a presumption, right? Because it's prima facie evidence of the law unless somebody objects to it. So that's what my motion objecting to the presumption of law here. And furthermore, the code is Roman civil law, which is a foreign jurisdiction. The common law is supposed to be the law here. And then he doubled down, the Idaho Code's the law. And that was it. Like, okay. You said it. I'm creating my record. I set him up. Now he's trapped. I already cited Peterson versus Peterson. The Idaho Code is not the law. But Eisman didn't know it then either. And in 2017, when he was actually my judge from clear back in 1995 there, 94 and 95, all the way to 1999 for my so-called felony case. I actually got to shake hands with him on a personal level down at the Idaho Capitol, talking about the President's Day or whatever. There was some sort of function thing that he spoke at down there, and I went up and I talked to him about it. But the thing is what did he say? That he'd worked his way all the way up to the Idaho Supreme Court. And he flat out standing there telling us, look, there is something wrong with our court system. He's like, I don't know what it is, but I'm telling you, there is something inherently wrong with our court system. Somebody needs to figure it out. And here's a man, Judge Eisman, who has always been a fair man. Every time I've been in front of him, witnessing other people start going. He's another one of them, Judge Watkins. People go off on him, whatever, and he remained calm, cool, collected, tried to talk calmly to people and calm people down and say, look, hey, this is the way it is, and this, what do you want to do here? What do you want me to do? What do you expect me to do? I've got a job to do here as a judge. But you yelling and screaming at, he was one of the good ones. Okay? He was fair. He denied stuff. You know? He didn't just play along to get along. But the real issue is it's the Roman civil law and it's the bar, which is why they want to say, oh, you got to have a license to practice law, because they want to protect their Roman civil law. Right? Because everything works through the Roman civil law of the code. And this is why we have heard many times, well, the Constitution doesn't apply in my courtroom. It's because it's all Roman civil law. The Constitution is part of the common law of the land. Are you picking up what I'm laying down here, folks? Another part of the Roman civil law is judicial canons, the code of professional conduct, code of ethics, code. Anytime you hear code, that is Roman civil law, a foreign jurisdiction. It is opposed to the laws of nature, the law of nations, and the common law. Just like I shared not too long ago, the Virginia Law School, whatever, they're talking about, well, yeah, the law of nations is part of the common law. That's right. That's what I've been saying for quite some time now. Once I figured it out, in reading Blackstone's Commentaries on the Laws of England, as well as Bouvet's Law Dictionary 1856, oh, yeah. Go to my website, kirkslawcorner.com. Download the 1856 Bouvet's Law Dictionary. Go look up law, civil. And it tells you that that's the ancient civil law of the Roman Empire. Oh yeah? Blackstone in his commentaries on the commentaries on the laws of England, he calls it out. Civil law, Roman Empire. That Stephan in the History of the Criminal Law of England, he calls it Roman law. Civil law is the Roman law. So, I'm not lying to you. And reading means reading. Jeremiah, you're talking about how to get into these courts. It's one, to get in. We have to bring the law, right? And when they're bringing this law against us, we object to that, right? That's in the pleading in the form of demur, which is a motion to dismiss, challenging jurisdiction. Oh yes, the Roman Empire did fall. Oh, it most certainly did. But it's London and Vatican, right? And D.C. That's the Tri-City state, which is the city of London, not London itself. And then the Vatican, that's the church, right? City of London is the bankers, which really is based out of Israel, which is the Jesuits. That's what's behind all of that. But yeah, very, very good start to read there in Bouvet's Law Dictionary 1856 under law, civil. Okay? And highly recommend reading Blackstone's Commentaries on the Laws of England, which, thanks to Jacqueline out there, I have all 4 volumes right here that I read from. Right? Look at that. See all them little sticky notes there? This is volume 1. Won't let me. There it is. There's volume 1. And then, is it this one? Where is it? No, volume 4. Volume 4 is the really good one. Okay, lots of good stuff here in Volume 4. Okay, Blackstone's Commentaries on the Laws of England. It is on avalon.yale.edu. And it's a little rough reading because F's or S's in certain situations, certain words. It's an older English, so I've kind of gotten used to it now, so I can pretty much read fluently, converting the F's into S's. Babylonian. Yep. Right, James? That's a good one. Tricks are for kids. Thank you, Rob, for posting that stuff out there on Facebook. But to ultimately answer your question there, Jeremiah, we evoke the common law. I claim my rights from the common law. And just like in State versus Clark, in the 2019 case, he claimed that Article 1, Section 17 protected him from the officer making an arrest without a warrant, and in his, and that's just what the judge was saying in my trial there, was, well, I'm familiar with State versus Clark, and that wasn't the merits of the case. This was about completing a misdemeanor. No, I'm reading exactly what it says, what the rule of law is, which is the common law, is that no person may be arrested without a warrant for a misdemeanor. It didn't say a completed misdemeanor. No, it's period. Any misdemeanor, except for breaches of the peace. And the only exception to the rule of law on making an arrest without a warrant is for felonies. That's it. You know how much freer we would be if that was adhered to? That's the Fourth Amendment. Right? The right of the people to be secure in their persons, papers, houses, and effects shall not be violated. And no warrant shall issue but upon probable cause, supported by oath or affirmation. Well, we had probable cause to make an arrest. No, you had probable cause to go get a warrant to make an arrest. Because that's what the Fourth Amendment reads. No warrant shall issue but upon probable cause. This is trickery. They're saying that they can make an arrest without a warrant based on probable cause. No, you have to have probable cause to get a warrant to make an arrest. So in the plain language of the Fourth Amendment, you have to have a warrant to make an arrest. The only exception to that rule of law, common law, is for felonies. That's it. And that's what they discovered in State versus Clark in 2019. What the rule of the common law is, as it is written, both in Blackstone's Commentaries on the Laws of England and Stephan in the History of the Criminal Law of England. And it's funny because that's exactly what I cited in my motion to dismiss and my motion to suppress in the very beginning of my case. Right straight from Blackstone's Commentaries on the Laws of England, Book 4, Section 289. That's exactly what they cited in State versus Clark in 2019. But I didn't find State versus Clark until here about a month and a half ago. But do I really need State versus Clark? Not when I have Blackstone. Right? So knowledge is power, right? That's it. Yep. And the Treatise on Arrest and False Imprisonment by Charles Wiseman. Okay. That's a good one. But Blackstone's Commentaries on the Laws of England, there ain't no getting around it, folks. And I'm seeing this more and more and more, that they are citing directly from, and it's the number one source, go-to source, is in fact Blackstone's Commentaries on the Laws of England. Because that was written right before our republic. Right before we declared our independence. So that is as close to the common law at the time as we can possibly get. And it would be after the first Charter of Virginia of 1606, the second Charter of Virginia 1609, and the third Charter of Virginia 1611-12, and then the actual very first instrument of government here in America is the Ordinance of Virginia 1621. That is the creation of the General Assembly. 1621. This is the American common law being made at the time, which Blackstone wrote his commentaries after that. It was 1770, what was it? Oh, it was 1983. No, I'm just kidding. That's when this was republished. Oh, yeah, that's right. It's written in like X's and L's and stuff for the date code. MDCCLXV. I want to say it was 1774. (1765) and 1769. So, right before the Revolutionary War. You're welcome, Karen. Thank you, Jacqueline. I definitely have an extreme passion for the law. And I'll be honest, where it comes from is because of me being abused as a kid. I think that's why I'm so passionate about our rights, is I don't like being abused. And now that I'm an adult, I don't have to tolerate it. I can do something about it. And knowledge is power. Without the knowledge, we have no power. So I am literally trying to empower each and every one of us, just like myself. And trust me, folks, I have kicked police officers' butts over parking lots, the Idaho Capitol, all over the place by citing law and calling them out. Knowledge literally empowers us. And this is the double-edged sword that God talks about, right? That our tongues are sharper than a double-edged sword. Okay? When we speak the law, it literally cuts the man down. Thank you, Amunzen58. You're very welcome. I really appreciate these comments, folks. I need that uplifting reassurance as well, because I have my down days too. It's like, why do I even keep doing this? Nobody's listening, nobody's learning, nobody's doing anything. But I know that's the evil talking, right? Trying to get me to quit. I know that I'm planting seeds. And I know that not everybody learns as fast as I do. I get it, right? I had a hard time dealing with that because I thought, well, everybody's the same, right? And like my counselor said back in 2007 there. No. Actually, it was 2006, 2007. No. We're not all the same. It doesn't mean that I'm better than you. I don't think that I'm better than anybody else. Okay? I'm plenty ignorant in lots of things, right? I'm not the most intelligent man on the planet. I'm not the most smartest man, and there's a difference between smarts and intelligence. Okay? I don't claim to know everything. That way I can't be held to know everything. So, I don't think I'm better than anybody else, right? Because smarts and intelligence doesn't have anything to do with what kind of character and how you treat your fellow man. Doesn't have any bearing on that. You can be dumber than a box of rocks and a sweetheart and a gentleman, and that will go much further than any intelligence or smartness of a man. Trust me. So, I keep going because I have faith. I have faith that this will get turned around. And the only way that it's going to happen is if we educate the people, which is why I'm here predominantly every Monday night for years. And remember, for those of you that have been around for a long time, Diesel D's, Jacqueline, and Wendy, and some other people, it used to be Mondays, Wednesdays, and Fridays, 3 nights a week, 2 hours a night. So, I'm here. I'm trying. But reading means reading. And here's the thing. I hated reading. You couldn't get me to read in school. Why do I need to read? I hated it. And now I kind of know why, because the English language is such a bastardized language, it didn't frickin' make sense. C-O-M-B, comb. B-O-M-B, boom. No, that's that other word. Huh? You're not making any sense. Which is which? Are there, and there? Over there? What? They are over there? What? English language is a bastardized language, folks. And no wonder why I had a hard time with it, because it's not logical. It doesn't make any logical sense. Which is why I'm extremely good at mathematics. I finished pre-algebra in 6th grade, folks. But to get me into, I get the basics of the English language, right? And was a pretty good speller. 4th and 5th grade spelling bee champ for my class, and I got, in fact, in 4th grade, I was 3rd for the top of the whole school in 4th grade. So, that's the whole noun, verb, adjective. I get the nouns and verbs now. Okay, I got some of those basic stuff. But when you get into the adjectives and all the extra stuff, okay, that's where I get lost. Sentence structure and that kind of stuff. But what has helped me is reading. So I'll be darned. That's the whole purpose behind reading, is to help us learn sentence structure, how to properly use certain words in connection with other words in a sentence. So now I get it, at, what, 10 years ago? But in the last 10 years, my reading has been exponential. Manslaughter, man's laughter. Right? They taught us to sound words out. Manslaughter is man's laughter. Try separating it as man and slaughter. Like slaughtering a cow. No, I do not have them on my website there, Jeremiah. The comments weren't scrolling because I scrolled back up and missed a whole bunch of comments over here. Sorry. I have posted them out on previous shows in the comments section and that kind of stuff. So, but highly recommend people join my Telegram channel. This Telegram channel is where I really put out a lot of stuff, documents and that kind of stuff, cases and that kind of stuff. I maintain my Facebook page, and yeah, I have a personal profile, which I don't really accept a whole lot of friend requests. I'm not a friend collector on Facebook. It's mainly for my family and close friends. But my Facebook page, Kirk's Law Corner, that's the one you want to follow if you're on Facebook. Rumble, X, and most importantly, Telegram. My private Telegram channel is the most predominant place that I put everything. Okay? So, in the description, it should all be in the description, a link to my Telegram channel. Ugh. Sorry to hear that, Jane. You got dyslexia. Yeah, that sucks. I'm sorry. Right? Start screwing up when you get all frustrated. Yep. But when I get that way, I just got to take a break. Right? Just got to take a break. Walk away. For me, I go smoke a cigarette. I go do something. Calm down. Think about something. Think about whatever. And sometimes I'll just okay, I'm done. When I get to that point where I'm kind of burnt out and I'm feeling it like that, I'm like, okay, I'm done. I've learned to just stop instead of getting all continue to getting frustrated and going into anger. I just stop. Say, okay, I get it. Take a break. Right, Wendy? Exactly, Michael. Yep. Go tink on something. Go turn some wrenches. Clean something out in the shop or something. Go tinker on something. I got the Harley to tink with. I've got a car to tink with. Truck to tink with. I got plenty of projects outside to work on. But I haven't been able to get to my projects that I wanted to work on this winter because I've been dealing with my mom's 5 cases. So the one case, the conservatorship case, is basically coming to an end. So we're almost basically done with that. And then my mom hired an attorney for the 2 property cases, because those really need to have somebody in there that knows what they're doing with that stuff. And he's starting to do a pretty good job over there. So we'll see what happens here in the next little bit when he does his request for discovery from them. So but yeah, here in a little while, I'm going to finally get a break when we get through these cases here, and I can actually enjoy life a little bit. I'm still going to have to be hustle and bustle on my own case, plus that I'm going to start a new case as a constitutional challenge, a motion for declaratory or a petition for declaratory judgment and injunctive relief. That's how you start a case and do constitutional challenges. So, but I'm going to be prepared for this stuff, and I'm not going to delay. I'm going to be kicking some butt on these cases. I'm not going to be messing around. So, but you know what, folks? I'm pretty freaking beat, and I know it's not quite 9 o'clock my time here, but I've had a good run at this for tonight, and thank you all for being here. Much love. God bless. And reading means reading, folks. Read. Gotta read. Gotta get this stuff. The only way. Knowledge is power. We have to gain this knowledge. It is the only way. They're preying on our ignorance, folks. There is no ifs, ands, or buts about it. So the sooner we get ourselves educated and gain this knowledge, the better off we'll all be. Okay? Thank you, Munson, Jacqueline, Diesel D's, Karen. Mark Bond, good to see you finally. Finally seen your comment. Seen a comment. But, breaking news. The House of Representatives introducing articles of impeachment to impeach Tim Walz and the Attorney General of Minnesota.